Time for another episode of the Politics with Paul podcast with your host, Paul Rader. Now, last week we talked about a potential 28th Amendment to the Constitution and what that would look like. So, we're going to stick with the Constitution this week. So, when a government official in the U.S. is sworn in to take a new office or they are taking the same office for a new term, they take an oath in which they vow, with some differences in how it's worded, to uphold and protect the U.S. Constitution. Same thing with the military. And it's not just federal level officials, the state and local level officials do it as well, with state officials also vowing to uphold the state constitutions. But we've seen time and time again that in these political battles and in various lawsuits, these various interpretations of constitutional law by political personalities like candidates, campaign officials, appointed officials, basically anybody involved with politics. So we all have these different concepts of what the Constitution says and means, but we all swear to uphold it. So, how exactly do we determine what the Constitution says and what it means? How do we interpret it? Well, that has been a debate since the beginning. We've had the debate over what are called enumerated versus implied powers ever since the early days. Enumerated meaning that it's explicitly laid out in the Constitution, and implied being that it's only inferred. Federalists often refer to implied powers, while Democratic Republicans who were born out of anti-federalists who initially were in opposition to the U.S. Constitution because they still wanted to stick with the Articles of Confederation back then, they their focus was solely on enumerated powers. They thought that these implied powers would lead to a federal government being unchecked, whereas Federalists, they saw it as these implied powers were needed to have a robust federal government that could respond to certain issues that maybe these enumerated powers would not always be able to address. Now, as for how vague, for lack of a better term, the US Constitution is, it's far less specific and wordy than a lot of these state constitutions are, or really pretty much every one of them. State constitutions are a lot more specific in what they address, whereas the Constitution is something like, I believe, 8,000, 9,000 words. It's far less specific and wordy than state constitutions are. Now, some parts are pretty clear and defined. Like, for example, the Constitution clearly states that we get two senators per state, two U.S. senators per state, and lifetime terms for Supreme Court judges. But there's also some of the more ambiguous pieces, like what's called the necessary and proper clause for Congress to make laws that are basically necessary and proper for the government to carry out function. What does that mean? That's one of those things that has been debated for a long time, specifically to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, etc., etc. Again, what that exactly means, that's been debated. And then there's somewhat vague clauses in the Constitution where there's some level of definition, but what exactly falls under that purview is not always as clear. For example, the Interstate Commerce Clause. So the federal government has the power to regulate interstate commerce, so commerce between one state and another. What falls under interstate commerce is a little bit unclear. It was in fact the subject of a major I'm drawing a blank on what the case was, but there was a major case in the 1930s when FDR was president, one of his New Deal acts. The argument was that it regulated interstate commerce, and the Supreme Court ruled it was not interstate commerce. I'm drawing a blank on which case that was. But anyways, interstate commerce is, a lot of times it's pretty well defined, but in other times there might be a little bit of argument as to what is commerce between one state or another. And then, of course, Congress can regulate trade between the U.S. and their countries. Now, another part of that enumerated versus implied powers debate back in the early days of the nation as we see it in the Bill of Rights. So Federalists believe that the first 10 amendments of the Constitution, they were basically already part of the US Constitution, while anti-federalists, who later became Democratic Republicans, didn't see it that way. And as sort of a compromise, the Bill of Rights was ratified a couple of years after the US Constitution. US Constitution fully ratified in 1789. The Bill of Rights are officially added to the US Constitution in 1791. And then part of that Bill of Rights is the Ninth and 10th Amendments. Ninth Amendment being rights not expressed in the Constitution are reserved to the people. So just because it's not stated in the Constitution does not mean that people do not get those rights. And then the 10th Amendment is where powers not given to the federal government belong to the states. And those two are also subject of debate as to what rights are under the purview of the Ninth Amendment, what powers are under the purview of the 10th Amendment. It's one of those many arguments and debates going on about what the Constitution explicitly says and what it is implying, or if it even infers anything in the first place. So there are three branches of government. There's the executive, there's the legislative, and the judicial. And the judicial branch is tasked with interpreting the Constitution, but it was not always like that. It wasn't until the Marbury versus Madison case in 1803 where Chief Justice John Marshall established SCOTUS's power, Supreme Court being SCOTUS for short, the power of judicial review for the Supreme Court. Prior to this case, SCOTUS was not actually given the authority to interpret the Constitution. And another early issue was whether the Bill of Rights applied to state governments. Early on, the Bill of Rights was actually only considered to be applicable to the federal government. The responsibility of such rights against state governments was delegated to the states, and it was the states' responsibility to incorporate that in their own constitutions. But the impetus for this change on this front was really the ratification of the 14th Amendment, specifically the Due Process Clause. And from that, we get it's called the Incorporation Doctrine. So, Due Process Clause imposes the Bill of Rights, the limitations from the Bill of Rights on the federal government. Those same limitations are imposed on the state governments as well in terms of what rights people have. So now you go more to the present day, and you have several different labels for these philosophies on interpreting the Constitution. People might not necessarily use these specific labels, but they're pretty common. Some people might use something similar. Like typically, you get either originalism or you get living constitutionalism. And a bit of an oversimplified definition, but originalism, it tends to be conservative judges tend to lean more to the originalism side, and it's more of a interpreting the Constitution in the context of the framers' time. Now, even that is not necessarily agreed upon by originalists. There's a subgroup called the textualists, which interpret the Constitution based strictly on how it's written, regardless of its intentions. For a lot of originalists, they look at it as what is the intention of the founding fathers or excuse me, rather the framers of the Constitution, because not all the framers or not all the founding fathers were framers of the Constitution. Some of the founding fathers, like Patrick Henry, were actually against the U.S. Constitution, and at least initially wanted to stick with the Articles of Confederation. Some originalists are textualists, where they don't even consider what the framers' intentions may or may not have been. They specifically, strictly just how is it written? That's what we got to go by. And on the flip side, you have the living constitutionalist. So those tend to be more liberal judges. And for them, the Constitution's meaning changes with different eras of U.S. history. Now, when it comes to these political debates, you often hear the term judicial activism. That tends to have negative connotations, really just used by one side of the aisle against the other to describe actions that, for whatever reason, they think that it's outside of the bounds of what the court is allowed to do. So maybe the two sides have completely different interpretations of a constitutional provision, or because SCOTUS overturned one of its previous rulings. And that's happened in 236 cases as of September 2024, according to constitution.congress.gov. So You hear it a lot from conservatives against liberal rulings, but you've also heard it from liberals against conservative rulings. So, with conservatives calling more liberal rulings judicial activist rulings, one example would be the Obergefell versus Hodges case from 2015, which ruled that same-sex marriage is protected by the Constitution. For a lot of conservatives, they said that the court applying the 14th Amendment's equal protection clause to same-sex marriage was judicial activism because the amendment had nothing to do with it. The intention of the 14th Amendment was not to be applied to same-sex marriage, and at least in the conservatives' view, in the originalist view. And conservatives will also argue that it contradicts the 10th Amendment because it infringes on the power of states to regulate same-sex marriage. Again, that's just what conservatives are saying about liberals. For liberals who see certain conservative rulings as uh, judicial activism, you saw it particularly with the Dobbs versus Jackson Women's Health Organization. That was the court case which reversed the Roe v. Wade ruling. So Roe v. Wade established, according to the ruling there, Roe v. Wade in 1973 dictated that that there was a constitutional right to abortion that was protected by the U.S. Constitution. With the Dobbs ruling, that reversed it and said that abortion was not a constitutional right. So for liberal judges or people with a more liberal philosophy, a living constitutionalist philosophy, they saw that as judicial activism because these judges, in their eyes, these judges went out of their way to overturn a precedent that had been set for the time, almost 50 years. And they would also argue that it goes against the Equal Protection Clause of the 14th Amendment because that would allow states, or because of the ability for states to ban abortion, that is infringing upon the equal protection that women would get. Again, that's just what liberals would say against conservatives, not saying one way or the other on either one of these cases is correct or not correct. It's just how a lot of them see it. But in the case of Roe v. Wade, that's not the only major court case where SCOTUS has changed its interpretation of laws or reversed precedent before. Like I said before, there's at least 236 cases where that's happened. So besides that Roe v. Wade ruling, one of the other really big instances was, in a way, was kind of actually reversing precedent twice. So in the case of racial inequality, we had the Dred Scott versus Sanford case in 1857, which at the time slavery was legal and slaves were considered property and did not have citizenship, and they didn't have any of those rights that were afforded to free people. Then you get to the Plessy versus Ferguson case in 1896, which doesn't totally reverse it. In the ruling, the idea, at least according to the judges, was that separate facilities, segregation was legal as long as these facilities were equal, the whole separate but equal doctrine. Then Brown versus Board of Education in 1854 completely overturns that and says separation of facilities for blacks and whites is inherently unequal and segregation is therefore unconstitutional. And then one more particularly big case was with Chevron USA versus Natural Resources Defense Council in 1984. It was kind of overturned by two cases actually earlier this year in January 2024. Back then, or prior to these 2024 rulings, there was what we called the Chevron deference, where federal courts deferred to a federal agency's interpretation of an ambiguous or unclear statute that Congress delegated to that agency to administer. The Loper Bright Enterprises versus Raimondo case and the Relentless Incorporated versus Department of Commerce case, the rulings there overturned the Chevron deference. So you have a couple of those cases of originalism versus living constitutionalism there, butting heads. Now, that's not to say that there aren't degrees of originalism and living constitutionalism, but if we're talking in general, the basic philosophies going against each other like that, originalism, more of the conservative what was the intention of the framers back in their time, or even a step further, the textualist saying just specifically what the Constitution says. Living constitutionalists, the meaning of the Constitution changes over time. So, what would some of these originalists and living constitutionalists say about their particular viewpoints? A couple of the major arguments you would hear. So, for originalists, the idea is that it's reducing judges wanting to impose their personal values on the law. To them, they're saying, well, we just got to look at it and what the framers intended. We can't have judges, or in their case, in their eyes, judicial activists dictating what the Constitution says. They would also say, if you don't even have a basic, unchanging meaning of the Constitution, what's the point of even having a Constitution? There has to be some sort of foundational meaning to what the Constitution says. And if they really want to change the meaning of the Constitution, then it should be left to the people to amend the Constitution if that's what's needed. And we've seen the Constitution amended 27 times over the course of over 230 years. Living constitutionalists, on the other hand, would say that you have to account for the changing times from the framers because they could not have predicted a lot of these issues that we have today. Issues of today, a lot of them are much different than those of the framers' time. And the framers were an eclectic group with different viewpoints, and it's difficult, if not impossible, to fully determine what their intentions were. A lot of aspects of the Constitution they didn't even agree on. It's really one giant compromise. And to them, originalism loses sight of the bigger picture, and it doesn't let judges prevent potential legal crises that come from inflexible interpretations of the Constitution. So, which one is right? Obviously, that's for you to decide, but that's just the basic idea between originalists and living constitutionalists. And then whenever you hear the term judicial activism, there's not really going to be a whole lot of people that actually describe themselves as such, but it's usually more of a negative label that either originalists apply to originalists apply to living constitutionalists, and living constitutionalists may apply to originalists if they try to overturn precedents, such as with the Roe v. Wade case. So, just something to think about whenever you hear the term judicial activism. But that does it for today's episode. Give you a basic sense of what these judicial philosophies are, and really, it's been an argument, been a debate ever since the Constitution was ratified. So, with that, we're going to end off with the random question of the day. And today's random question is, do you subscribe to the shopping cart theory? So if you don't know what the shopping cart theory is, it's basically the idea of if you are at the grocery store or supermarket or any sort of market where you have a shopping cart and nobody is there around to criticize you, would you just leave your shopping cart where it is in a parking space, for example, or would you actually walk over to place it in a shopping cart return? And I got to tell you, I have never worked in retail or for like grocery stores or anything like that, and it drives me up a wall anytime I see somebody do that. It's just unbelievably lazy. Just return your cart to it. It takes a lot for me to not say anything. And I actually one time had somebody who whistled to me, did not even say, "Hey, can you take this cart back?" Again, I've never worked in retail, and I wasn't even dressed like I was working there. And he just shoved the cart towards me and said thank you after. It's like, you could actually ask if I could put it there. If you asked, I would have, yeah, sure, I would have done it. But to assume that I was going to do that, it's just one of those things that's just exceedingly annoying. Just put the cart there. Just make the cart returner's job a little easier. You don't have to take it all the way back to the store. Put it in the shopping cart return. But I think constitutionalists and living originalists can agree on that at least. Hopefully. But anyways, that's going to do it for this episode. Once again, as always, thank you so much for listening. Like, comment, subscribe, and share the video with all your friends and your network. You can follow me on Facebook at Paul Rader, author and speaker. My website, paulrader.org. My LinkedIn profile, which is simply just Paul Rader. My podcast, obviously, as well. And I also have a book out. It's been out for a few years now called Why Independents Rarely Win Elections and How They Could Become More Competitive. Get that on Amazon in ebook and paperback format. But other than that, I think that does it for today. So hopefully this shed a little bit of light on one of the many, many political debates of our time that really has been around since the very beginning of this country. So with that all said, until next time, take care.